For judgment, item number 1.
The appeal accordingly stands dismissed. Send back the records.
Dismissal. Obliged.
For admission, item number 2.
May I please, Your Lordship, the writ appeal filed against the order which is passed into WPC number 9119 is pending in the principal seat. And
We had directed, passed a similar order last week or yesterday.
Yes, my lord. I'm appearing as requested by Mr. S.K. Mehdi, who is at the other court.
No, one of the matters we had passed an order that writ appeal is pending in the principal seat. Same matter.
Yes, my lord. It is the same matter.
What is the writ appeal number?
this
320 of 2023, my lord.
When is it fixed? 10th,
7
Seven-
January.
7 January. Okay. The learned counsel for the parties have jointly informed that on the present subject matter, there is WA
320.
328
320
320 of
of 2023.
23 pending in the principal bench, which is scheduled for consideration on 7/1/2025 for Sapara. In view of the aforesaid submission, matters are adjourned to be listed after,
My lord,
The-
if it may be listed on 21st January.
may be listed on 21/1/2025.
Obliged, Your Lordship.
Obliged, my lord.
Item number 3.
Item 3.
My lord, I'm appearing for the respondent.
Yes. Madam, you are invisible almost.
I know, my lord.
No, yeah. Okay. What is the submission? You are for the respondent.
Yes, item 3 is a contempt matter, my lord.
Okay. Have you filed your response?
We have filed our response, and I have filed my show cause reply, and the matter is ready for hearing, my lord. But my lord, if this matter can be posted on some other day, because due to bereavement in the family, I have to attend the funeral, my lord.
Yes. What do you say?
Yes, Lordship, I'm appearing on behalf of my senior, Miss Valentina, and
On this submission, no objection.
yes, Lordship, we haven't received a copy of the report.
Ms. So-and-so learned counsel appearing online has submitted that due to some bereavement, she is not in a position to argue this matter today for Sapara. In view of the above aforesaid submission, matter is adjourned to be listed immediately after the winter vacation.
Obliged, Lordship.
I'm deeply obliged.
Item number 4.
My lord, in this matter, we have filed affidavit in reply.
Okay,
So if the matter may be fixed for admission hearing, my lord.
okay. Who is for the other side? Government?
Miss Mary, my lord. From the video, my lord.
Video?
She was taking up the case, my lord, from the government side.
Oh.
Similar order
The
may be
learned
passed, my lord.
counsel for the petitioner. Item number?
Item number 4, my lord.
Petitioner has submitted that rejoinder affidavit has been filed and the matter can be taken up for admission hearing. Full stop para. List for admission hearing after the winter vacation.
Much obliged.
Item number 5.
My lord, I think none appear from the petitioner side.
Item 5, anybody is appearing for the petitioner? What is the matter?
The matter is regarding freezing of account.
Is there any interim order?
Yes, the account was already unfreezed by the State Bank.
None appears for the petitioner on call.
In the last court, the Kala, representative of the Kala, have submitted his her power. So today, I think it's the time for submitting his affidavit.
Who is appearing for Kala? Anyone appearing from Kala? Nobody. None appears for the petitioner on call. Whereas the learned counsel for
Appearing for 1 and 2, respondent number 1 and 2,
respondent
State
1
Bank.
and 2 and
For respondent number 3.
1 and 2.
Respondent
As well
number
as
5.
Ms. So-and-so, give the name, sir, for respondent number 3. You are also appearing for somebody? No, your friend.
Respondent number 5, my lord.
5, huh? All of them, Nima, are present. Para. In the interest of justice, matter is adjourned to be listed immediately after the winter vacation.
Much obliged.
Item number 6.
Lordship, I'm appearing on behalf of my senior, Mr. Bilaram Eng, for the
Yes.
petitioner. My lord, if we may granted further time to submit our rejoinder affidavit.
You have
To the-
not filed your rejoinder.
Yes, my lord.
My lord, I already filed my affidavit. I am for respondent number 1.
We grant some time to file rejoinder?
my lord.
Okay. On the prayer made on behalf of the petitioner, 4 weeks' time is granted to file rejoinder affidavit.
Obliged.
Obliged, my lord.
Item number 7.
And again, my lord, as my senior, Mr. Bilaram Eng, is unavailable and as he is still out of station, my lord, if the matter may be taken up again on Thursday.
So what is this matter about?
My lords, the matter is, I have filed an application before the Land Trial Court for freezing the bank account of the private respondents, but my application was ultimately dismissed, my lord. It's a simple matter, my lord. I have no objection provided an attempt may be made on that day to dispose of the matter, my lord, because it has been pending for some time,
Thursday. We can try on Thursday.
my lord.
Thursday your senior will be available.
Yes, my lord. Thursday, so,
A request has been made for adjournment on behalf of the learned counsel appearing on behalf of the respondent numbers 5 and 6.
yes, my lord, 5 and 6.
5 and 6. Full stop. Para. On the other hand, Sri So-and-so learned counsel for the petitioner has expressed some urgency. Para. 24 matter. We'll have it after the vacation. We'll fix a date.
My lord,
List on, we'll have it on 15th. We are opening on 13th, 15th we'll have the matter. 15th for 15th of January. ODB day, okay. Then 14th. 14th is okay for you? 14th?
My lord, my lord.
Okay.
Item number 8.
Yes.
And my lord, due to the aforesaid reason, if the matter may be posted again after vacation. No objection, my lord.
On a request made on behalf of the sole respondent, matter is adjourned to be listed after the winter vacation.
Very much obliged, my lord.
Item
Have
number
you
9.
filed, this is RFA, records have come. Or has it been admitted or not? Earlier case, has it been
No,
admitted?
my lord, it has been admitted.
Records have come or not? Records were called for? Definitely, probably.
No.
Let us see.
Not called. No, my lord, the court has not been called for.
Records have come. Now, see the first order. of admission?
Thursday can admit without consent. Ay, ka-phone na ano.
Give me the order sheet. Order sheet of this court. Oh, this, okay. IA for what? Oh, there is a delay condonation. No, not this one. Item number 8.
Oh, first time din.
Then why delay condonation? Where is the IA? Oh, it is the stage of delay condonation.
Supposed to be.
It is a delay has been condoned or not? Delay has been condoned.
Lordship, the IA has been disposed and the main appeal is came up for the first time today.
Okay. Delay has been condoned. Okay. Oh, appeal has come for admission.
Yes.
Yet to be admitted. Okay. Then what did we write? For admission. Okay.
Much obliged, my lord.
Item number 9.
Nine RFA.
Yes, Lordship. Lordship, in the last court, a step was taken for service of notice. But still, respondents are still not represented, it seems. This is, Lordship, a challenge against heirship certificate which was issued without adducing evidence, my lord.
It's a regular first appeal.
My lord, yes.
Why notice was issued? Regular first appeal are to be admitted. Why notice issued?
As direction was made in the last court date, my lord, for service of notice.
Okay. Heard Sri So-and-so learned counsel for the appellant who by means of this appeal filed under section so-and-so from the cost title, has assailed an order dated 4/9/2024 passed by the so-and-so in so-and-so. Please take it from the cost title. Para, admit. Para, call for the records. Let steps be taken for service of notice upon the sole respondent by registered post with AD. Steps within 2 days. Okay.
Will be obliged.
First day it should have been admitted. It's a regular
My
appeal.
lord. My lord.
No scope of issuing any notice.
Item number 10.
But Mr. Counsel takes fresh steps after admission. Okay, doesn't matter. You have to take fresh steps now. Oh. Yes, what is this? Yes, what is this?
My lord, a rejoinder affidavit was filed by the petitioner and we had received. Pleadings are complete and it may be listed for admission hearing, my lord.
Okay. When did you file the rejoinder?
8/11/2024.
Yes.
The learned counsel for the parties have jointly submitted that pleadings are complete and the matter can be taken up for admission hearing. Para, list for admission hearing after the winter vacation.
Obliged.
Is there an interim order? No.
No, my lord.
Orders, item number 11.
May it please your lordship.
Yes.
My lord, in this case, there is a delay of 520 days in filing the connected appeal.
Okay.
Now, the delay is neither willful or deliberate, but rather due to the prosecution of the present case, the impugn order before the wrong forum.
Objections have been filed.
Yes, your lordship.
Okay.
Everything is ready. Otherwise,
So we can hear this. Yes, please. How much is the delay?
520 days.
520 days.
Yes, it relates to inheritance of property, your lordship. Now, the brief facts of the case, your lordship, is that one property.
No, we are not on the merits.
All right.
We are on the delay part.
Yes, I'm just reading that the suit property is 1496, which belonged to my mother,
Okay.
whereas the respondent is the granddaughter. I am the son. I'm the sole surviving son.
Appellant is the son.
I am the son, sole surviving son. And whereas the respondent is the granddaughter.
Okay. Through
My brother's daughter.
through another son.
Through another son who has passed away.
Who has passed away.
Passed away. Predeceased our mother.
Okay.
So that is the crux of the case, your lordship. So what happened is that there is a delay of 520 days. Now the heirship certificate, which is in contention today, was issued to the present respondent on 25/11/2020.
It was a contested matter.
No notice was issued.
No notice was issued.
Yes. It was issued on the same date itself.
Oh.
So
But okay. And what about your part? When did you come to know?
yes, your lordship. Regarding that, I was in the service and in the defense, and I retired on 30th of November of 2020. So this was issued right before my retirement.
Yes.
So I was unaware of this fact.
Okay.
Now, as far as the delay is concerned, for the period between 15/3/2020 to 2022, that, in my humble opinion, would be covered by the suo motu case taken up by the Supreme Court in light of the COVID pandemic.
Okay.
And thereafter, in the same judgment and order, in the same suo motu judgment and order, another period of 90 days limitation was granted, counting from the period from 1/3/2022 to 29/5/2022. So in our humble opinion, delay would have to be counted from 30th of May of 2022. In any event, your lordship, the matter was the matter between the parties was referred to the Lok Adalat. Vide order dated 12/2/2021, passed by the Lok Adalat.
Lok Adalat in what proceedings?
Between the same parties.
No, in what proceedings? In an execution case or what?
No, nothing like that, your lordship. I had submitted an application to the Lok Adalat saying that, please,
Okay.
I would like to have some kind of reconciliation if there is a possibility.
Oh.
So, however, the Lok Adalat was of the opinion that as an heirship certificate has already been issued to the respondent, they cannot take up the matter. In any event, due to wrong legal advice that I received, instead of challenging the heirship certificate that was issued to the respondent, I myself submitted an heirship certificate bearing number 333 of 21 before the court of the senior civil judge in respect of the same property. And again, without issuing notice, that was allowed. Vide order dated 23/2/2021. Vide order dated 23/2/2021. I was also issued an heirship certificate in respect of the same property. Now, upon learning of this fact, the respondent filed a review petition against my heirship certificate, which was allowed vide order dated 17/6/2022. The review was allowed vide order dated 17/6/2022.
Yes.
Now, again, your lordship, due to wrong legal advice, I submitted a civil suit dated, civil suit number 77 of 2022, before the court of the senior civil judge on 1/8/2022, praying for a declaration amongst others that I am the rightful title holder of that property. Now, after having realized that I have approached the wrong forum, I made an application for a prayer for withdrawal of my civil suit. And via order dated 7/9/2023, 7/9/2023, I was allowed to withdraw my civil suit. Thereafter, I applied for a certified true copy of the present order that is under challenge. And thereafter, Your Lordship, there was a court holiday between 21/10/2023 to 29/10/2023. It was a High Court holiday on account of puja.
When did you apply? Certified copy 7/9.
18/10.
18/10.
Because I took some time to engage
Certified copy of which order?
of this present impugn order. This
Which one?
25/11/2020. The first airship,
Yes.
the first order whereby airship certificate was
yes.
issued to the respondent is so that I can put the same to challenge before this honorable court.
But after this, if you had applied beyond the prescribed period of limitation, will the court holidays make any impact? There will be no impact.
Right. In any event, Your Lordship, I'm just highlighting that, I'm just narrating the sequence of events.
Okay.
So thereafter, Your Lordship, I finally had the opportunity to file this present RFA on 1st of November of 23.
Present RFA filed.
Yes.
Okay.
So although there is a delay of 520 days counted from
25/11.
Yes, in light of the suo motu case issued by the Honorable Apex Court, and also in light of Section 17 of the Limitation Act, as
What
per
is-
our
what is-
calculation,
Yes.
as per our calculation, the actual date of delay is 45 days.
Okay.
So that is our humble submission as far as the period of delay is concerned, Your Lordship.
Yes.
My Lord, firstly, what I want to submit is that there is an incorrect statement, suppression of material facts in the application. If I may take Your Lordship to the original IA, that is at page number 5, Roman number 4, at the last sentence. Yes. It's
Page number 5.
5, yes. Roman number 4, last sentence.
Just a minute, please. Of the IA.
The IA, the original IA.
Just a minute. Written objection. Page 5.
Yes, page 5.
Yes, 4.
Last sentence. If I may read, my Lord.
Yes.
It is regarding about the knowledge about the existence of the respondent airship certificate. It was only upon receipt of the review application the applicant appellant came to learn of the existence of airship certificate number 1135 of 2020 in the year 2022. So they pleaded that they came to know the existence of the respondent airship certificate under challenge now only in the year 2022. But if I may take the Lordship to the WO written objection.
Yes, just a minute.
Yes.
Your objection, written objection.
Yes, yes.
By whom?
The the respondent number 1. So, page number 10, Annex 1.
Written objection, yes. Written objection by respondent number 1, yes.
Yes, page number 10, Annex 1. If I may read the contents of the order, this is the law.
Just a minute, please. Yes, please.
Yes, if I may read the contents of the order. This order is passed on 12/02/2021, way back in 12/02/2021.
Yes.
Yes, the parties are present. On discussion, it is learned that the airship certificate HC had already been granted to the petitioner. Such being the position, the case is closed and advised the OP. The OP herein is the applicant herein. Advised the OP to approach law court for proper adjudication. Yes. In their IA, they pleaded that their knowledge was only in the year 2022 when they received review application.
Yes.
But here, the order clearly stated that parties are present, both the applicant and the respondent herein are present before the Lok Adalat, and airship certificate had been highlighted herein, and the applicant herein had already advised to approach the law court for proper adjudication. In this regard, my lord, if I may, I want to rely on the Honorable Supreme Court judgment in 2010, Volume 8 SCC 685.
2010, 8 SCC,
SCC
685.
685, yes.
Paragraph?
9, paragraph 9, page number 690. Yeah, if I may read, my lord.
Please.
It is clear from a bare reading of the above paragraph that the applicant were totally clueless about pursuing their appeal. They have acted irresponsibly and even with negligence. Besides this, they have not approached the court with clean hands. The applicant who seek aid of the court for exercising its discretionary power for condoning the delay is expected to state correct facts and not state lies before the court. Approaching the court with unclean hands itself is a ground for rejection of such application. And if I may read again the para 39, 700, page 700.
Para 39.
39, yes.
Yes, please.
On an analysis of the above principle, we now refer to the merit of the application in hand. As already noticed, except for a vague averment that the legal representatives were not aware of the pendency of the appeal before this court, there is no other justifiable reason stated in the one-page application. We have already held that the application does not contain correct and true facts. Thus, one of bona fide, it is imputable to the applicant. There is no reason or sufficient cause shown as to what steps were taken during this period and why immediate steps were not taken by the applicant, even after they immediately came to know of the pendency of the appeal before this court. So here in the case also the condonation application is rejected. So, secondly, whether they could come under the COVID exemption, if I may elaborate that part. The total days delay, the order was passed on 25/11/2020.
Correct.
Yes. Till filing of this appeal, the days delay is more 1,070 days. They simply cut off those delays which falls under the COVID extension period.
Yes.
So whether they are entitled to the benefit of such COVID exemption, right from just after passing of the order and before the appeal is preferred, the applicant had already participated in 4 proceedings before the appeal. One is at Lok Adalat, and the other one is at Women Commission. And before this honorable court also, just after the Lok Adalat case was closed,
Dates.
the Lok
One is before Lok Adalat.
yeah, one is
before Women's Commission.
yes, one is before Women Commission. As complaint case number 18 of 2022.
And 2 more. When two more dates? When? Where?
They have challenged the Women Commissioner by way of writ, that is WPC number.
No, that is okay. You said on 4 occasions,
Yes,
in spite of taking the excuse of COVID,
yes,
they had appeared on 4 occasions.
Yes.
4 proceedings.
yes.
One is before the Lok Adalat.
Yeah,
One is before the
before Women
Women's
Commission. And they have challenged the Women Commission order before this honorable court by way of writ petition. That is writ petition C number 113 of 2022.
Yes.
And they have also filed civil suit.
77 of 2022.
Oh, yes, civil suit is civil suit number 77 of 2022.
Okay.
So, knowingly the fact that at the Lok Adalat, the existence about the respondent heirship certificate, they did not appeal. So, they are not acted in a diligent manner. So, I want to rely on the Supreme Court judgment in (2021) Volume 2, SCC 317. That is Sagufa, Ahmed, and others versus Apara Supply Board, Polywood Products Private Limited, and others. The operative portion which I want to rely on is at page 322,
Paragraph
17.
17.
Yes. If I may read.
Yes, please.
But we do not think that the appellants can take refuge under the above order in cognizance of extension of limitation. What was extended by the above order of this court was only the period of limitation and not the period up to which days delay can be condoned in exercise of discretion conferred by the statute. The above order passed by this court was intended to benefit vigilant litigants who were prevented due to the pandemic and the lockdown from initiating proceeding within the period of limitation prescribed by the general or special law. It is needless to point out the law of limitation find its root into Latin maxims, one of which is vigilantibus et non dormintibus jura subvenient, which means that the law will assist only those who are vigilant about their rights and not those who are slip over them. So again, in the this is the Delhi High Court just when I went to the relevant portion which I wanted to rely on is at paragraph 10.
Just a minute, please. 2021 SCC Online. Delhi
5398.
5398. Name HT Media. Para?
10.
Yes, please.
Yes. It is thus more than apparent that the condition that prevailed due to the pandemic did not actually impact the defendants to prevent them from interacting with their counsel and filing appropriate application and replies before this court. To that extent, the order of the Supreme Court in cognizance for extension or limitation would not be applicable to the facts of the case. So, my lord, hearing the case also, just after passing of the order and in between filing of the appeal, the applicant had already participated for proceeding, as I have stated earlier. So, the COVID has no bar upon the applicant to take a legal course in appropriate manner. So, my learned friend has already stated that the civil suit number 77 of 2022, which they filed before the senior civil judges, wrong advice, due to wrong advice. But that is not the wrong advice at all. See, the purpose of that civil suit and the inheritance now under challenge is completely different matter. In civil suit, the appellant had prayed for declaring him as ownership over the said property. But here, the case is inheritance of property. So, that is not, the senior civil judge, the lower court had jurisdiction to completely adjudicate the said civil suit. Whether the said LSC may be registered in his mother name or in the respondent name.
Okay.
So, my lord, if I may take this is the additional affidavit of the applicant. Page number 5, para 9.
Yes, please.
If I may read, my lord, just one sentence, the first sentence. Yes.
Yes.
Yes. The applicant appellant filed civil suit number 77 of 2022 on dated 01/08/2022, praying for a declaration that he is the rightful owner of the landed property covered by LSC number CAD 1496 of 2012. At the time of filing of this civil suit, until now, the said LSC number is registered in the name of his mother, until that also. So, there is the learned trial court had jurisdiction to completely adjudicate upon the said civil suit. So we cannot simply say that it is the wrong advice and the wrong forum. We cannot say that the learned trial court is the wrong forum, since inheritance matter and claiming ownership, rightful ownership over the property is entirely different matter. So they cannot take the benefit of Section 14 of the Limitation Act, which is only provided for exclusion of time proceeding bona fide in court without jurisdiction. The trial court has conclusive jurisdiction to entertain upon the said civil suit. So they cannot take refuse under Section 14 of the Limitation Act. So as I said earlier, the total amount
You
of...
say that the provisions of section 14 will not be applicable.
Yes, will not
Because
be.
that court was a court with jurisdiction.
Yes, the
It
court
was
has
not
jurisdiction.
bona fide pursuit in a
Yes.
forum without jurisdiction.
Yes, yes.
So application of 14 will not be there.
Will not be there. Yes. So apart from that, the total days delay is 1,070 days. So now their claim is that only 520 days delay in their application. So they simply cut off those days delays which falls as part of, which falls under the COVID exemption. That is more than 460 days. They did not count in the application also. They simply short for exclusion of the time only. Firstly, in the original application, they counted as 45 days delays. Then they amended it, it rose up to 520 days. So as per my calculation, the days delay from the date of order is 1,070 days. So, in my opinion, there is no reason to condone the delay in the present case. So,
No, in fact, when the matter was registered,
yes,
the officer said it is not 45, it is 520 days.
yes, yes. But they did not count those days delay which falls under the COVID exemption period.
Okay.
So I pray that your Lordship may.
Okay, though we are not supposed to go into the merits of the case
Yes.
before even condoning the delay or taking a call whether to condone or not to condone. But what do you say that you are the granddaughter and he is the son of the deceased, on whose name the heirship certificate is concerned?
Yes.
Are you disputing this fact?
No, not disputing that, but I have to something to say about the existence of that LSC also. See, at those time, me and my grandmother staying together in a rented house. So one person, namely H.B. Thapa, had on seeing our miserable condition, so had gifted this portion of land. So the said portion of land was registered in my mother's name.
In your mother's name?
My grandmother's
Grandmother's name?
Yes.
Okay. Yes, any reply from any rejoinder from your side?
Just a small reply, Your Lordship. My learned friend has concluded his submission. Number one is that regarding that number of days, Your Lordship, we had inadvertently mentioned it as 45 days, and after the registry had pointed out, and the same was that issue, particular issue was taken up by this honorable court, and as such, with the permission of this honorable court, we had submitted that additional affidavit to explain that, because we had, by inadvertence, we had simply deducted those delay. As in any event, Your Lordship, my learned friend has relied on a few judgments of the apex court which has been read out, but I will not repeat them. But in all those cases, what appears to be the directions of the apex court was that one should be vigilant, one should take due care of their case. In that regard, Your Lordship, at the outset, what I would like to take Your Lordship's attention is to the date of the order of the Lok Adalat. Lok Adalat's order is dated 12/2/2021. 12/2/2021 is the date of the Lok Adalat, wherein I was directed basically to go to a court of appropriate forum.
Correct.
Now, when did I file my heirship certificate, rightly or wrongly? It was the order was issued on 23rd of February of 21, immediately, in the same month.
Which one?
This is heirship certificate 333 of 21, which was issued in my favor by order dated 23/2/2021, in respect of the same property. As a result, at that point of time, there were 2 airship certificates in respect of the same property. So in the same month itself, rightly or wrongly, this can be found at page 27 of my original application. So thereafter, Your Lordship,
No, see, in the Lok Adalat, you were aware that there was an order in his favor.
correct,
Instead of challenging that order,
I filed an airship
you filed
application
an independent airship certificate.
again.
In that airship certificate, did you even mention about the order in favor of the respondent? Obviously no, because that airship certificate was issued on the same day.
Right,
You filed on 23rd, it was issued on 23rd.
right,
If there is even a passing mention, reference to a existing airship certificate, the presiding officer would have at least gone into the matter. What is it? What is it
most
going
probably,
on?
Your Lordship, most probably. I don't have a
So,
copy of
so
that
how do you
particular.
justify your action of making an application for an independent airship certificate, knowing fully well that there was an airship certificate already issued in favor of your learned colleague's client, which was also taken up in the Lok Adalat, which was not entertained.
Correct, Your Lordship. But Your Lordship, one thing has to be borne in mind is that I'm just a simple serviceman, retired serviceman. All I know is that I presented.
Those will consider and see what they have done. They could have challenged your airship certificate of 23 to 2021. They have not done. They have in fact filed a review, which is
Right.
probably the proper course of action,
Right,
because the matter was already decided in their favor.
right,
Whether that decision is good or bad, if we are inclined to condone the matter, that's a different matter.
right.
But as a matter of fact, there was already matter was adjudicated, maybe on the same day, and there was a certificate. In spite of that, further certificate in your name, subsequently, he files a review has been allowed.
Right. And thereafter, Your Lordship, just to highlight the sequence of events that I was not sitting idly. The fact is that the order of the Women's Commission, rightly or wrongly, that was passed, which can be found at page 13 of my learned friend's written objection, was issued on 18th of July of 2022. 18th of July of 2022.
Yes.
And immediately, it was basically an order of eviction issued by the Women's Commission. So that was put to challenge before this honorable court by way of a writ petition, and it was allowed. But what is more important as far as this application is concerned, Your Lordship, is that this civil suit, which I...
But the eviction, the basis of the eviction, which was the cause of action before the Women's Commission, was the airship certificate.
Right.
So he may be he may be correct in submitting that you had full knowledge when the Women's Commission had passed an order on 18/7/2022, and the same was put to challenge in the High Court in WPC 113 of 2022.
Right.
That was challenge made by you in the year 2022.
Right.
And this present application, present appeal, when have you filed?
November of 23.
1/11/2023. Even simultaneously filing the application, writ application in 2022, you would have come to this court. Matter would have been slightly different. Yes, Women's Commission, I need to challenge. I have challenged. But so far airship is concerned, I am challenging by following the proper procedure.
Yes, but unfortunately, Your Lordship, I was...
Thereafter, again, you had filed civil suit.
That was as per the legal instructions that I received from the concerned councils that I had engaged. Now, at that, what I would like to highlight is that, Your Lordship,
What was the decree you had prayed for in the civil suit?
for a declaration that I'm the rightful owner of the...
Was any challenge made to the airship certificate?
No, my lord, it was not.
If that was also made, you would have said that yes, wrong forum, I have gone there.
Correct, Your Lordship. Absolutely correct. But then, Your Lordship, what the fact of the matter is that when the Women's Commission order was passed on the 18th of July,
Correct.
I had immediately filed a civil suit on the 1st of August. and simultaneously also filed a writ petition.
Okay.
So it is very unfortunate. Your Lordship is absolutely correct in highlighting all those legal technicalities which was not done, but which ought to have been done. But unfortunately, the fact of the matter is that this is not a case where I was sitting idly. It was just a sad situation where I have been given very, very wrong advice. And in light of that, Your Lordship, one cannot lose sight of the fact that notice was never issued in the original heirship certificate. In fact, my humble submission before this honorable court is that even if this appeal is allowed, let's say presuming that the delay is condoned and the appeal is allowed, no prejudice would be caused to the respondent inasmuch as she can still adjudicate her rights before the proper forum. Now, my learned friend had slightly mentioned that she used to live with her grandmother till the time of her demise. Those are question of facts which needs to be proven by way of evidence. And as I stated earlier, Your Lordship, I am a serviceman and I had left the state of Mizoram to serve my country. Now, in the provisions of the Mizo Marriage Inheritance of Property Act 2014, it is clearly mentioned that if a son leaves his house for work related, that would not be construed as leaving the ancestral home.
Okay, those are on the aspect of merits of the appeal.
Right, understood. So I'm not pressing on that. In any event, Your Lordship, my humble submission before this honorable court is that this is not a case where I was sitting idly over my rights, and as such, as the record has clearly shown, I have taken steps rightly or wrongly before the authorities which I thought were the correct authorities, the correct forum, and in light of my submission, Your Lordship, I would like to rely on one small judgment of the Apex Court. This is 2005 3 SEC 752.
2005?
Volume 3, SCC 752.
Para?
12. Just 2 lines, Your Lordship. This is that state of Nagaland versus
Oh, Lipokao.
Yes.
Technicalities.
Technicalities. So that's why it says that if the refusal to condone the delay results in grave miscarriage of justice, it would be a good ground to condone the delay. Now, in the instant case, Your Lordship, even if the delay is condoned, it would not be the end of the
Lipokao,
road.
which paragraph? 17?
12.
12. This is Passage judgment, I think.
So, Your Lordship knows this judgment very well, so I did not read it out again. But in light of this judgment, my Lord, my only submission before this honorable court is that the refusal to condone the delay will result in irreparable loss, harm, and injury to me. Whereas, even if it is allowed, no prejudice will be caused to the respondent. She will still have all the opportunity to make her claim before the appropriate forum, Your Lordship, provided the appeal is allowed. That is my humble submission.
But what about the right which has been vested upon her by this inheritance certificate? This right is a right conferred by an adjudication process. Limitation Act is also a substantial act.
In my humble opinion, Your Lordship, there was never any adjudication. Not a single notice was never issued. So there's a...
No, let us not use the word adjudication. Let us just use the expression conferment, maybe on the same date. That conferment has vested some right upon him, his client. And this Limitation Act is not only a procedural aspect, it has got a substantial aspect also.
Understood.
Of substantial right vest upon the other party. And that right you cannot just brush aside. It has been settled. It is not a technical issue that yes.
We are not trying to brush aside the rights of the respondent. We are trying to ascertain who is the rightful owner of the property. That's all.
To do away with the rights which have been vested upon the other party, the burden is heavy upon you.
Because
you want the decision to confer the certificate to be examined by this court as an appellate court. And once we intend to examine, we go to the root of the matter, everything. It's not a revision.
Understood.
We go as appellate court, everything will be done. which was done should have been done by a trial court. So it opens everything.
Right. But
Okay,
a fact of the matter, Your Lordship, is that it is not denied by the respondent that I am the sole surviving son and she is the granddaughter.
We have asked this question to your colleague. He is not denying, but
He's not
he
denying
said
that.
something else. Unless the granddaughter was staying with her grandmother.
Yes. But my lord, this is a condonation application. So
No, I'm
if
just
we
repeating
have
your words, that's all.
going about the merits of the case, then we have to consider this application alone. See, I
Okay,
want to.
we'll consider.
Yes.
We'll consider.
My lord, if I may have one judgment
Regarding?
regarding the limitation, this is a legal judgment, 2024 judgment. See,
Where the points have been taken out, point by point.
yes,
Which one? Which judgment? New one?
yes. Para 26, page 6, there is a law laid down by the Honorable Supreme Court.
Yes. This we know. Yes. 24 judgment, yes.
In this case, also, merits of the case are not required to be considered.
26, paragraph 26, point by point it has been done, all the points, isn't it?
Yes, yes. So,
There is one more judgment recently, where all the points have been, all the other earlier cases were relied upon, referred, discussed.
yes.
Here what has been discussed? Katiji has been discussed. Katiji, Lipao Kao. Yes, Katiji, I think this has been, Katiji has been discussed. Come to paragraph 16.
Yes, my lord. Yes,
In collected land acquisition, Anantnag and others versus Katiji.
yes.
Sufficient cause.
So,
Okay, we'll take care of this also. We'll reserve this, we'll pass tomorrow or day after, okay? We'll have this order tomorrow or day after. Tomorrow there is a DB. Or before the DB maybe, if it's ready, otherwise day after, okay? Heard so and so. Land Council so and so. Hearing is concluded. Judgment is reserved.
Obliged, Your
hello.
Lordship.
May not be required. You may send this. And I put the notes.
Item number 12.
May I please, Your Lordship, my lord?
Yes,
This is an NDPS matter, my lord, commercial quantity, my lord.
okay.
May I
I'm
please,
appearing
Your
on behalf
Lordship?
of my senior Mr. B.K. Mahajan, my lord. My lord, the investigation is going on. It's a DRI matter, my lord, Director Revenue Intelligence. So the case diary may be called for, or maybe the DRI maintains case records, my lord. So that may be called for, my lord.
It's come for the first time. Last time it was, I think,
Yes, my lord. It
You have
listed
taken
yesterday,
time.
my lord. Listed yesterday, my lord, but some technical difficulty, we could not connect with
and
the
your
link, my lord.
colleague was trying to have this matter after the vacation.
Yes, my lord. Some miscommunication on the part of her.
Bail matter, if it's done after the vacation, what will it serve? We
Yes,
do not
ma'am.
know, tomorrow we might reject it, that's a different matter, but.
Yes, yes, my lord. Yes, my lord.
Okay, heard Sri Mahajan, learned counsel appearing online, who has preferred this application under Swensu, praying for Bill Swensu. Huh? Call for the case diary. It's in the stage of investigation.
Investigation, my lord. 121 days behind the bar, my lord.
Call for the case diary. Sri Swensu, you are for the.
My lord, the counsel for the respondent and the opposite party is out of station, my lord. He's my colleague. I'm appearing on his
Sri
behalf, my
Swensu,
lord.
learned counsel appearing on instruction of Sri Swensu. He's the standing counsel. You're
He's out of station, my lord.
No, he's the standing counsel
My lord.
of DRI.
DRI, my lord.
Is directed to obtain the case diary. Full stop. When do we fix?
My lord, after vacation, my lord.
We'll fix on the reopening day, Mr. Mahajan.
Yes, yes, my lord.
On 14th, 13th we are reopening. Here the vacation is long.
Yes,
So
my lord,
14th.
yes, my lord.
On 14th.
Obliged.
Highly appraised, Lordship, obliged.
Item number 13.
May it
Yes.
please your lordship. My lord, parties have made an amicable settlement outside court.
Okay.
My lord, if I may, my lord, as per the last court's order, a settlement was attempted to be arrived at. So, but till date, my lord, that information has not been imparted to us, to the councils.
You
So-
get the instructions?
Yes, my lord.
Yes.
While the learned counsel for the appellant has submitted that the matter has been amicably settled, comma, the learned counsel for the respondent submits that he is yet to receive instructions
My lord.
in this regard. Para, considering the above, the matter is adjourned to enable the learned counsel for the respondent to obtain necessary instructions. Full stop list after the winter vacation.
Obliged.
Deeply obliged.
Hearing list, item number 5.
May it please your lordship. My lord, this is a case, an appeal filed against the judgment and order dated 23/4/2021, passed in civil suit number 1 of 2017. Now, at the outset, your lordship, I would like to narrate the fact that the present plaintiff appellant used to be married with the defendant number 1. The defendant number 1 is my ex-husband, whereas the defendant number 2 is my ex-father-in-law. So during our marriage, your lordship, what happened was that
Who's for the other side?
My lords, I'm for the respondent 1 and 2.
And other respondents?
others are not represented, your lordship. They're not necessary parties, so to say.
Appellant is the plaintiff.
My lord.
Appellant is the plaintiff.
My lord.
Suit for? Suit was for?
I apologize, your lordship.
The suit was filed for what?
Yes, the suit was filed for directing the defendant, particularly defendant 1 and 2, to either pay an amount of rupees 25 lakhs 40,000 as the cost for construction of a 3-story house, or in the alternative, to declare the plaintiff appellant as the legal owner of the property covered by LSC number 279 of 1980. This is located at Lunglei district.
Just a suit for direction. To pay?
Rupees 25 lakhs 40,000
Yes.
Or in the alternative, to declare that the property belongs to the plaintiff.
Okay.
Now, before we get into the evidence, Your
You
Lordship,
said the defendant 1 is ex-husband.
ex-husband, 2 is my ex-father-in-law.
Okay.
Now, before I get into the evidence and the nitty-gritty, Your Lordship, at the outset, I think my learned friend and I had a small discussion outside the court, and we are both in agreement that there are certain contradictions in the judgment and order passed by the learned trial court. At the outset, what I would like to mention is that during our time of marriage, this particular LSC, the property, used to be registered in the name of my father-in-law. That is the defendant number 2.
When was the marriage?
That was in 2012.
And the dissolution?
After a year, Lordship.
2013.
So I apologize, 2016. 2016.
A dissolution by way of a divorce.
Divorced. It's by way of sumswa. Basically, it's where the bride returns the bride money to the husbands, and then she leaves the property. She leaves her husband. So that is not
Divorce by the
wife.
By the local custom.
Local custom.
Customary.
Customary. This fact is not in dispute, Your Lordship.
Okay, okay.
This fact is not in dispute. So, just to, before we get into the evidence, Your Lordship,
Oh, yes.
just to give you a gist of the case, is that during our time of marriage, this property belonged to my father-in-law.
Correct.
And since I was the only one with enough CIBIL score to obtain a housing loan, the property was mutated, contested by them in my name. So the property was mutated into my name. And thereafter,
Yes.
thereafter I had availed for a housing loan from the respondent number 3 bank, that is Mizoram Rural Bank.
Yes.
So according to my calculation, with the amount of money, loan that I had availed from the bank plus the interest that was paid, I had spent approximately about 25,40,000 for construction of a 3-story RCC house within this property.
About 25?
25,40,000 as per my rough calculation, I'd spent this much, inclusive of the loan taken and the interest paid.
Yes.
So after the dissolution of our marriage, so I said that, look, the property anyways belongs to you. You return my money, or I'm going to court to declare that this property is mine. So either one, please give me one. So that was my contention. We were sent for a pre-trial lok adalat, but nothing fruitful could come out. As a result, I was constrained to fight a civil suit. Now, on the other hand, the contention of the defendant number 2 in particular, who had filed a counterclaim, is that he was unaware of the mutation.
Yes.
So that was their case.
Okay.
So that basically boils to those 2 points only, my lord. How much I spent versus whether the mutation took place in legally or not.
The mutation was put to challenge.
As per, yes, by filing a counterclaim.
No. The mutation cannot be challenged in a counterclaim, in a suit.
That is another issue, my lord.
You cannot challenge a mutation in a suit. There is a different procedure prescribed.
Right.
Was it done? Did you approach the revenue authorities?
No, my lord. As far as my letter friend can answer better.
But in the counterclaim, was there a claim made for a declaration to against the mutation order.
Yes, my lord. Your lordship can kindly turn to the paper book, page 146.
146.
146 is the judgment and order.
Yes.
At page 149.
Just a minute, 149. What about the counter, the issue number 9?
I apologize, Your Lordship.
What about the issue number 9 at 150? Counterclaim is entitled to any relief at 150.
Yes, I have
Issue
it.
number 9.
Yes.
How is it answered?
At 149, the prayer portion of the counterclaim is reproduced at the last paragraph, para 8, and the portion which is written in italic in number 1 itself.
Yeah, that is okay. How was issue number 9 answered?
Right and title was given to them.
Paragraph?
Yes. 162. Para 59, issue number 9.
Just a minute. Other reference extended. You tell us one thing, the mutation what was the basis of the mutation?
There was a relevant revenue forms were submitted, which was also countersigned by the defendant number 2.
No. See, mutation is only about the names being changed.
Right.
What is the basis of the change? Simply by form you cannot
No,
change.
it's by way of a gift.
Gift.
Yes.
Was it proved?
In all honesty, I don't think it was proven.
No. How was the property first transferred to your name? Only after the property is transferred either through gift or sale or inheritance, you can apply for mutation.
Gift, my lord. At page 87, annexure B2.
Gift, was it registered?
Not registered. It was just simply a revenue form. So that is one issue, Your Lordship. But although out here at issue number 9, the learned trial court had held that right and title will vest with the defendant number 2. But at the same time, at issue number 2, at page 1, issue number 2 starts from page 151. Now the issue is whether the plaintiff and the defendant number 1 were married at the relevant point of time. So, sorry, this is not it. Issue 3, page 152. Whether LSC number 276 of 1980 was mutated in the name of the plaintiff by following necessary procedure or not. At page 154 is the finding at para 27.
Just give us a minute.
Sure.
One
154, para 27. Your Lordship has it?
Yes.
May I read? Mutation of names in the land settlement certificate is an executive matter which required strict procedures to be complied with not only by the applicants but also by the concerned authorities with village council concerned. On the basis of available evidence on records with the facts and circumstances of the case as discussed above, this court is of the considered opinion that nobody used or borrowed the said LSC number so-and-so belonging to the defendant number 2 counterclaimant since it was kept by him in his custody and mutation was done by the competent authority by following necessary procedure and the present issue is decided in the positive. So on one hand, the trial court is saying that mutation was done as per law. But on the other hand, at issue number 9, the learned trial court is saying that right and title will vest with the defendant number 2.
The fact of mutation and the legality of mutation, these are two different aspects, distinct aspects.
I agree.
The fact of mutation is in your favor because there is no fraud or alleged that somebody has changed the name. But it is, as a matter of fact, your name is there in the mutation. But how, while deciding, examining, what was the basis of making the mutation, it's a different question that has been answered differently.
Right.
You may be correct to some extent that this issue and that issue should have been clubbed together, and because in the mutation, the name of your client was there.
Right.
And the counterclaim is that it should be interfered with.
Right.
Counterclaim has been allowed. But at the same time, this observation appears to be somewhat contradictory. Yeah, you
Right,
may be
right.
correct in stating that.
Another point of controversy which my learned friend and I agree on, so to say, to a certain extent, is
Why cannot you sit and talk, settle the matter? Now who is in possession?
they are in possession.
I'm in possession, my lord. My lord, with regard to the
See, the matter, the loan, who had spent the amount for the construction, that is for the parties to know. Without going through the evidence, we cannot jump to a conclusion that it was his client or your client. You know what has actually happened. She is already separated. She is no longer the wife of defendant number 1, neither the daughter-in-law of the defendant number 2. She claims that she had spent 25 lakhs 40,000 or something. It may be less. Let us assume that it is less. But at the same time, we cannot just say that she has not spent any amount because loan was in her name. Whether it will give her any right to claim any amount, that's a different matter for you. Can't you sit and discuss? Was there any?
We can make an endeavor, Your Lordship.
Was any endeavor made during the course of this proceeding, not only the appeal, even the civil suit?
Just a pre-trial.
Pre-litigation.
Pre-trial.
Pre-litigation was there.
Pre-litigation.
How's the mediation in this bench?
I have my trust in it. I think.
Is mediation done? In this bench?
Mediation is done, but not on a regular basis, so to say. I mean, not only after
just a minute.
fortnightly.
We have mediators appointed. See, we are just loud thinking. We are supposed to have mediators in each of the benches. Principal bench we have, as a personal knowledge I know. And we have been referring matters for mediation. This is a fit case because parties, though the relationship is no longer there, at one point of time there was a relationship between the wife and the daughter-in-law. So you can sit and talk. Doesn't mean that you have to come to a conclusion.
I understand.
But if you come to a conclusion, that would be a final conclusion and no further litigation. It's for the interest of justice. Without asked our court master, and you may also inquire if we have mediators for the High Court. Where do your party belong? Which district?
Lunglei district, my lord.
Lunglei district.
How far is it?
It's
About 5 hours.
5 to 6 hours drive.
5 hours.
From here.
Okay.
Yes.
You kindly inquire whether in the district court at Lunglei you have a mediator, a venue for a mediator to sit and have a discussion in the interest of the parties, because we don't want the parties to unnecessarily travel 5 hours, 6 hours and for no purpose. First, if something positive comes out, then we can have a sitting here. That's not an issue.
My lord.
Traveling 5 hours, 6 hours for 2-3 days is also better than fighting out litigation.
Correct, my lord. In fact, Your Lordship, the pre-litigation Lok Adalat was held right after the separation. So obviously the emotional status after 8 years might be different also.
Yeah. You can always try. See, it doesn't happen in one day. Parties are very rigid. We have seen parties very, very rigid. To make them flexible, it takes time. Then after you're flexible and easy, then you can really apply your mind. Otherwise, if you're rigid, you'll not be thinking in a rational manner.
Right. We can make an attempt. Your Lordship.
You take instructions on the aspect, okay? Please write. The present appeal concerns a dispute between the appellant, who was the wife and the daughter-in-law, wife of the defendant number 1 and the daughter-in-law of the defendant number 2. Full stop. The marriage was in the year 2012, which was dissolved in the year 2016, which is not in dispute. Full stop. The dispute is, however, with regard to a monetary claim over a loan in the name of the appellant for house building over the plot of land which was initially in the name of the defendant number 2. Full stop. As per the appellant, the land was mutated in her name by a gift deed.
If I may interject, my lord, I don't think there was any gift deed executed.
No, he says. Okay.
It's only
was
form.
mutated in her name.
For availing housing loan only, my lord. That's in the evidence.
Mutated in her name through a form so as to avail house building loan as her CIBIL was eligible for such loan. What's the para? Without going further into the merits, this court is of the opinion that an endeavor should be made to settle the matter out of court. Full stop. The learned counsel are accordingly directed to take instructions on the aforesaid aspect and also on the availability of mediation facility in this court as well as in the concerned district of Lunglai. Full stop. List this matter on 14th of January for instructions. Okay?
Yes, yes. Deeply obliged.
Item number 6.
Yes.
May I please, Lordship? Lordship, this is the make appeal.
Okay. Other side? Yes.
I'm for respondent number 2, my lord.
Okay. So that's one. Number 2 is you are the owner. Appellant is the owner.
Appellant, actually, the owner, the registered owner is the respondent number 2, my lord. And
the appellant is the buyer of the aforesaid vehicle, accident vehicle. I'm the registered owner.
And the
document has not been
liability
changed.
has been settled upon you.
Yes, my lord.
And who is the claimant?
Claimant is not represented.
Served.
Served, yes. Not served. The
Not
whereabout we cannot trace out, my lord.
You had gone for paper publication, I think.
Yes, we had done that's the service also. I mean, we are
Paper
trying
publication. There was paper publication also.
Yes,
Newspaper.
paper publication also.
Okay, served.
Within the local newspaper also.
Okay, okay. How much is the amount involved?
My lord, the amount awarded by the tribunal is rupees 39,25,800.
Death case.
Death case, my lord, yes. By calculating the monthly income at the tune of 29,000. And
What was he doing?
blacksmith, he is a blacksmith.
How was the income proved?
The income proof is the village council president had issued the acknowledgement letter. He was also produced before the tribunal, but he said that he did not see the deceased receiving his income. So only by his status as village council president, so that cannot be relied upon. So only said that
Your challenge is structured on what?
with regard to mainly confined to with regard to the negligence, rash negligence. The tribunal stated that the accident happens due to the rash negligence driving of the driver who is driving the truck, offending truck. Because, my lord, with regard to that negligence, while the criminal case was pending before the trial court, the outcome of the trial court was not known, my lord, till pronouncement of the judgment award of this tribunal, my lord. So,
But can that be a ground? Suppose there is a mechanical failure of a vehicle resulting in an accident. There is no aspect of rash and negligent driving, assuming in a case. Because of some mechanical failure of the judgment of the vehicle, the accident happens. Can you say that I am not liable to pay the compensation?
my lord, in this
You
case,
means either the owner, or if you are indemnified by the insurance company, the insurance company. It's a matter of thought that if an accident happens because of your action, whether it was intention or no intention, whether there is rash driving or not, accident is an accident.
that is
Can
very
you
true,
go
my
into
lord.
that aspect of the matter? So that is why we're again putting the question to you. What are the grounds of challenge? Are you challenging on the quantum, number one?
Number one is with regard to the monthly income, my lord.
Monthly,
The quantum.
that is quantum.
Yes, my lord.
Quantum. So
The
the
quantum.
monthly income was not proved,
Not true.
not duly proved. So it could not have been 39 lakhs. It could have
Yes,
been less.
my
That
lord.
is one.
My lord.
Any other grounds?
My other ground is with regard to the rash and negligent driving, because the present claim is made under Section 166 of the Motor Vehicles Act.
Yes.
So, in order to claim that compensation under Section 166, the claimant is bound to establish the rash and negligent driving.
Let us see 166 Motor Vehicles Act. It is not under 163.
No, my lord. This is under 166.
Structured. Yes, please read. Please read. You don't have the Motor
My lord,
Vehicles Act.
my apology, my lord. The MV Act is not with me, but I can get it from the.
You have the Motor Vehicles Act at least.
My lord, here I can read. An application for compensation arising out of an accident of the nature specified in subsection 1 of section 165 may be made A, by the person who sustained the injury, or B, by the owner of the property, or C, where death has resulted from the accident by all or any of the legal representatives of the deceased, or by any agent duly authorized by the person injured or all of any of the legal representatives of the deceased, as the case may be, provided that where all the legal representatives of the deceased have not joined in any such application for compensation, the application shall be made on behalf of or for the benefit of all the legal representatives of the deceased and the legal representatives of thieves who have not so joined shall be imputed as respondents to the application. Number 2, every application under subsection 1 shall be made at the option of the claimant, either to the claims tribunal having jurisdiction over the area in which the accident occurred and to the claims tribunal within the local limits of whose jurisdiction the claimant resides and carries on business, or within the local limits of whose jurisdiction the defendant resides, and shall be in such form or contain such particulars as may be prescribed. Provided that where no claims for compensation under Section 140 is made in such application, the application shall contain a separate statement to that effect immediately before the signature of the applicant.
From where are you making the submission that present negligent is a condition precedent? I think you'll need some time. We'll have this after the vacation. Come prepare properly.
My lord, here, yes, with regard to that negligence, the section 166 is
Yes.
required to be, the negligence and rash negligence driving, that is required to be proved, my lord. But after the amendment of that Motor Vehicles Act, my lord.
Yes.
That particular provision was slightly amended, my lord, modified.
Yes.
It seems.
So when was this accident? This accident was in which year?
This accident happens in the year 2015.
Prior to the accident?
2014, 13.
Prior to the amendment?
Prior to the amendment.
Where is the pre-amendment act?
2019.
Because these provisions have come in 2019.
Yes, my lord.
You have the earlier act.
And the claim application was made in 2015.
You have the earlier act.
Earlier act.
You
is
bring
not-
the earlier act.
My lord.
Come prepared with it. At least have those papers xeroxed and place it before the court. It will be
My
easier.
lord.
We'll have it after the vacation.
My
We'll
lord.
fix a date. Is there any stay order?
No, my lord.
Claimant got any money or not?
Not yet, my lord.
They have also not appeared. Do not know what is
yes.
their stage. On a request made by Sri Sri Learned Counsel for the appellant, matter is adjourned to enable him to place the relevant provisions of the Motor Vehicles Act prior to the amendment in the year 2019. Okay?
My lord, my lord.
List after the vacation.
My lord.